At the core of our identity is our natural personhood, an intrinsic status protected under international law. Article 16 of the International Covenant on Civil and Political Rights guarantees the recognition of every person's legal personality, a protection that supersedes domestic laws. This recognition is absolute, unalterable, and non-negotiable. Under Article 2 of the same covenant, member states, including Canada, are obligated to integrate these protections into their domestic legal systems. This means our natural personhood, and the rights that flow from it, must form the foundation of all laws and governance. These protections ensure statutory systems serve individuals, not the other way around. No government or institution can rightfully limit or diminish the recognition of our natural personhood. For instance, forcing individuals into statutory recognition, such as requiring licenses or classifying them as corporate persons, violates these absolute rights and principles of international law. While natural personhood underpins our rights, statutory systems are tools meant to serve, not control, individuals. Authority within these systems, such as that of a mayor, derives from the consent of natural persons to be governed under fairness, justice, and the rule of law. This authority is conditional, granted solely for upholding the rights of individuals. Yet this balance often shifts. Instead of serving people, statutory systems sometimes impose obligations that undermine natural personhood. A mayor, for example, is empowered to govern under the rule of law but must act within the bounds of justice and fairness. Their power is not inherent. It exists to uphold the rights of natural persons. When statutory systems overstep, demanding submission that conflicts with absolute rights, they betray their intended purpose. Forcing individuals into statutory roles or imposing undue limitations violates the principles they were created to protect. Recognizing this dynamic empowers individuals to hold systems accountable. Every time a public official interacts with an individual, they operate under the color of law, assuming statutory authority. They often claim a duty to statutory law that conflicts with the absolute rights guaranteed under Article 16 of the ICCPR. Such actions strip away natural personhood, replacing it with a statutory identity. By claiming you owe a duty to statutory law, they disregard your inherent, unalienable rights. This is a direct assault on your legal personality, which cannot be forced or abridged. Public officers have a legal obligation to act within the law and respect these principles. Yet violations are common when officials impose statutory obligations without consent. To assert your rights, you must recognize and challenge such overreaches, demanding accountability and reminding officials of their duty to uphold justice and fairness. The same system used to enforce compliance must also hold public officials accountable. Operating within the law reminds them that the same rules bind them as well. This shift is not about retaliation but restoring balance, reminding the system it must serve, not control the people. Mayors, as municipal leaders and justices of the peace, are custodians of these principles. Their role demands full awareness of absolute rights, including Article 16 of the ICCPR, which cannot be limited or abridged. They must act with justice and fairness, recognizing that their authority comes from the people they serve. When mayors neglect these principles, they undermine the rule of law and violate the trust placed in them. It is our responsibility as natural persons to hold them accountable and remind them that they serve justice, not stand above it.